coming out on a Thursday evening. We are all time poor, so it's nice that I can do something for all of you and hopefully answer a few questions. Now, normally I would actually ask people to interrupt me while I'm speaking just to give me some feedback on things that are of interest or might be relevant, to expand on them a bit more. And I understand where Eric's coming from, so any specific questions, leave them till the end. But if there's a topic that you want me to cover a bit more thoroughly, just put your hand up or interrupt me, and that's fine. I'm happy to talk about specific things. There's just so much to get across with IP. I'll introduce myself just briefly. I founded Chiliad IP, we are more than 10 years old, about 13 years old now, and that was after working in technology commercialisation and also practising as a patent attorney. So it's from that background that I tend to speak. So I hope that this session will be a bit more informative and a bit more strategic. But if there's anything specific that you want me to delve into, please just let me know. My technical background is in the pharma, biotech and medtech field, and for that reason I've brought my colleague Chris, who has a more engineering and applied background than I do. So between the two of us, hopefully any questions at the end we can help give you a bit of clarity and help field your questions. My background, I've also done an MBA, so getting that business strategy behind how we direct our IP portfolios and IP protection is really what we get at in our practice. We don't like to see IP rights that don't get utilised or don't add value. So that's really where we like to think our point of difference is. And of course, it's being recorded, this session is being recorded, so please don't disclose any confidential information. And we can leave those sorts of discussions, any specific discussions, to the very end. Now, the way that I like to break down these sessions to kind of touch on a few different things, has anyone been through the IP protection or the patent protection process in the past? Oh, my condolences, but you've survived and you've come out tonight anyway. I won't go too deeply into the process involved, which is quite complicated and varies quite a bit from country to country. But I'll sort of touch on more what the substance and strategy behind various rights are and what the scope of protection is. I'll then talk about disclosure because it's the perpetual problem with invention and innovation. How do you manage disclosure? So we'll talk a little bit about that. We'll talk about what IP strategy is, and I like to think of it as a leader for anything that we then do in IP protection. And I always like to touch on things that inventors often get asked. We have our own perspective on what the right answer is, because the right answer is not necessarily the answer that the person asking the question always wants. So I'll take a little bit of a pause in between each topic and make sure everyone's happy with what I've covered and whether anything needs to be covered off in a bit more detail. But yeah, ask any questions to elaborate at any time. So I'll start with just a bit of a primer on IP rights. What is IP? Technically speaking, IP is a collection of various rights. Patents, trademarks, designs, plant breeders' rights, copyright and circuit layouts. It also includes non-rights, and these are can be a bit more flexible and interesting. Trade secrets, confidential information and know-how. IP rights, you must apply for them, except for copyright and unregistered trademarks. Then you have a collection of rights that are non-rights or informal rights that also form part of this broader idea of intellectual property that exists through things like agreements, contracts, agreements between parties to do different things to maintain confidentiality. So IP can be, we like to consider it fairly broadly to understand what the best form of protection for any given business or product might be. So as an inventor, you're most likely interested in patents, designs, trademarks and copyright. Patents protect how something works. Designs protect how something looks, the aesthetic qualities of typically a product. Trademarks protect the origin of a good or service. So they act as a badge of origin. And copyright protects literary or artistic works, and that's actually quite a really broad suite of rights. It includes things like software, choreography, all sorts of creative works. Now, each of those rights, they're often, with new products and new businesses, they're often layered. We don't normally see one right exist without some other form of protection. So a nice example that we like to give is if you think of an Apple product. So it's not come out well in the overhead, but you might have, if you look at some of the original phone technology, just the broad concept of the Apple device, the Apple phone. It was protected by a patent, a process patent. It was protected by the Apple logo, and it was protected by design right, protecting the aesthetic qualities of the very first handset. So any given product might have multiple rights wrapped around it to protect it. It's always worth appreciating, I think, that IP rights have come about through a history of an understanding that there's a need for public disclosure of new invention and technology in exchange for the incentive to create. So the IP rights systems exist to provide a quid pro quo between the broader public interest and the interest of the creator. So the idea is that a monopoly right is tolerated, if you like, from the broader community, from the public, in exchange for the complete disclosure of an invention. So the state give the exclusive right to commercialise in exchange for knowledge that other people, other members of the community might build upon. It's an important nuance, I think, because often people feel that they are entitled to IP rights, but it tends to, the procedure involved is largely in place to protect the public interest. So that sort of adds a lot of cost and a lot of procedure around obtaining especially patent rights. So some nuances of IP rights. In terms of the public interest, we don't really see the public interest met quite as well. Sometimes through the maintaining of trade secrets, the public interest is better served by the disclosure of knowledge. So this particular article is about how forceps, a fairly common invention or product, if you like, was maintained a trade secret for a very long time and eventually was protected and then precluded from use from other medical professionals. So there is a significant public interest in the disclosure of new inventions to the public. This, I don't want to go into a lot of detail in the process involved in obtaining different IP rights, but this is essentially a bit of a rundown of, that's better, of different types of intellectual property rights. They can overlap one another. In Australia, they can overlap one another and they can coexist. Generally, the trend that you see is the scope of rights, the term, and the breadth of what's protected when the public is releasing more of that broader scope, longer term, to an applicant. The application process tends to be more expensive and more arduous. So that's the general sense of what happens when you apply for IP rights. Patent rights protect the functionality of a product. It's couched very, very broadly in terms of what patents can protect. Essentially any novel and inventive artificially created state of affairs. So the effect of a herbicide, for instance, can be patented. It's a very, very broad, conceptually broad group of things that can be patented, but the application process is very long, expensive, and it's difficult. The bar is very high to meet the requirements for patentability. Designs have a shorter term. The scope of rights that you obtain, because they are limited to the aesthetic appearance of a product, mean that the application process is less rigorous, is more cost effective and more streamlined. Plant breeders' rights sit in a bit of a different category where they have a reasonably long term, but the scope of what's protected depends on the variety itself. So a part of what has led to the sort of protection that's given for plant breeders' rights reflects the efforts involved in developing new breeds. So there is a requirement that the new plant breeds need to be shown as being stable, stability needs to be established, and it needs to come out through the application process that this plant variety is indeed a new distinctive variety. Copyright subsists upon creation. There's no application process for copyright in Australia. Once the work is created, it attracts copyright. Circuit layouts are much the same, but the term of a circuit layout is much shorter. So trademarks sit a little bit in a slightly different category. They tend to protect the public interest by educating the public on the origin of a particular good or service. So a trademark acts as a badge of origin, which can help to protect the marketplace as well as the trader around copycats, because at the end of the day, the public are also harmed if they're deceived into buying something that they believe to be from one source and in fact it's not. Trade secrets are an interesting right because they can essentially be held perpetually, provided that the secret can be maintained. So they're really limited to those sorts of scenarios where a trade secret can be maintained without the secret being disclosed. So, for example, if a product can be reverse engineered, it's near impossible to maintain a trade secret for that new product. So I'll just delve into the requirements, the basic requirements for patentability. When you develop something new, you'll be thinking, well, is this patentable? What would be protected? Is there any point? So I'll just touch on the requirements for patents and designs to give you an idea of what we're thinking when we think, is this something worth doing? Firstly, would it qualify? Is what we've invented a qualifying product? And then what IP right would best fit for that product to give it the broadest protection? So the requirements for patentability are essentially three. There are three substantive requirements. The first is novelty, the second is inventiveness, and the third is industrial applicability. There are other requirements, but they vary from country to country, and they're not what we consider substantive requirements. They're usually requirements that the applicant can meet after they've filed an application. So an assessment of novelty involves a side-by-side comparison of a patent claim with a disclosure. So a claim, if you file a patent application, you'll be seeking rights that are articulated in a series of one-sentence statements that we call claims. A claim will list a certain set of features. For example, if you have a claim for a chair, you might specify something that has 4 legs and is upright and can be sat upon. So that's the sort of language we would use in a patent claim. But for a patent claim to be novel, we would assess it against all literature that's known, and we would determine whether that each of the claimed features in that claim is disclosed in any one document. So it really is this side-by-side comparison where you are taking the claim of an application and comparing it to any product or any written document to see whether there's a match. The disclosure that invalidates novelty can be any kind of disclosure. It can be a document, it can be an act. So conference presentations and trade shows are often where we see people go, oh, wow, people are responding very well, the market's responding very well to this new product. Perhaps we should look to do something about it. And a novelty-destroying disclosure also includes self-disclosure. So there are some exceptions to this, but on the whole, we have to think of any disclosure of our own product can be used to invalidate our own patent if it hasn't been applied for first. Now, going to inventiveness, this is still a requirement that involves this sort of side-by-side comparison. Inventiveness is essentially like novelty, except the one distinguishing feature that's different between your claim and a product that's similar has to be a little bit more creative, a little bit higher, a little bit more inventive. So a lot of the time that we spend working with the Patent Office on behalf of clients is ascertaining or arguing whether a claim is inventive or not. So there are lots of tests that have been established through precedent, and if I were to stand and talk about all of them, I would be here for a very long time. And they vary from country to country, but essentially we do have a lot of harmony across countries on what inventiveness looks like. So typically, if a patent can be granted in a country like Europe, it will probably be granted anywhere else as well. Industrial applicability it's a requirement that essentially specifies that the thing that's patented has to be something commercial. And beyond that, we have a requirement around subject matter. So there are some types of things, some categories of things that even though they are commercially applicable, from a public policy perspective, different countries have decided we can't have patents. We can't grant patents for that. One is methods for treatment of human bodies. This is essentially to prevent anyone patenting a method for performing a surgery. That would not be something that we would think is in the public interest, so that's an exclusion category across most countries. But I think the one that's most controversial is software patents. So in Australia, we've probably the last 10 years had a fairly uncertain relationship with software patents and whether we grant them, whether we don't. The US they will grant software patents if they're claimed in a certain way and with certain language. The European Patent Office have a laundry list of things that they do and don't accept patents for. Software is on that list, but in certain circumstances, if we draft claims in a particular way, they can be granted for software type inventions. So if anyone were to say to you, you can't get a software patent, it's very much a maybe you can, maybe you can't situation. They could be right, they could be wrong. Now turning to designs, a registrable design must be new, similar to the idea of novelty. It mustn't be disclosed in any published document before, and it must be distinctive. So it must be different in overall impression. So similarly, with patents, it involves a side-by-side comparison of a document or a product or a thing that exists with a design application. We use a thing called a statement of monopoly to specify what part of a design is protected, but the hurdle for designs is much lower. It's also worth noting that the US have a funny sort of hybrid system called a design patent. So it's technically a patent application, but it's a design patent. So the requirements are very different. but they are more onerous than what we would see here in Australia or in Europe. And then we have non-rights, trade secrets and know-how. Trade secrets can only really be put usefully in place if it is possible to not reverse engineer the product. So and there has to be some protection around secrecy. So typically people will sign non-disclosure agreements and protect confidentiality. It's fairly limited in effectiveness in reality. And I'm not sure how many of you have heard the tales about the Coca-Cola formulation. So the idea is that that trade secret is maintained by two executives separately holding half the formula, and they never meet, they never come together. The two halves of the formula are held in completely different places, and no one knows enough to be able to bring them together. So that's sort of an extreme example of how a trade secret can be maintained. And no one really knows if it's even true, this story about Coke and their magic formula. But who knows? It's an interesting idea on the sorts of usefulness, the sorts of applications you can use trade secrets for. Know-how is a really funny one. And I often get this question where someone asks a key employee, particularly a technical one, will leave an organisation. And the question is, well, they were working on a thing. Now, who owns that thing? Because it's not really fair if someone has built capabilities in a very specific field but can't continue to work in that field. But similarly, if an organisation has paid for someone, paid an employee to develop something, they should be entitled to protect it. So it's a very, very difficult area, and often if you're ever employed to do something quite niche and specific, just be aware that contracts can specify what you can and can't do even after you leave the organisation, and there's a lot of dispute in this particular area as well, and I'm sure it'll continue to go on. So as a patent attorney, I can be pleased that we have patent rights to resolve that kind of issue. So it's nice that this idea that you can publicly disclose and still be protected, I think, is a really mutually beneficial one. So I've been talking a lot about disclosure. Actually, I should pause there and ask if anyone, I think I'm going to move away from any more specifics on particular rights, but if anyone wants me to speak at greater length on any specific right or no? All right. So I'm not sure how many of you have been asked to pitch what you're working on? Yep. Yeah. This is the perennial problem. How do you either engage contractors, pitch for investment funding, just pitch, even disclosing what you're doing to government to get co-investment and support for what you're doing? What do you do? And it's too soon to file a patent, or you're not funded yet to do it. Just to be completely clear, disclosure of certain details can invalidate patent rights. They can invalidate unprotected rights, not just patents, predominantly patents, but also designs and trade secrets and know-how. I mean, if you had a very robust strategy for maintaining a trade secret, it would be a very difficult exercise to go and get external funding for it, because I'm not sure, whether non-disclosure agreements are rigorous enough to maintain confidentiality if it's the only form of protection that you have in place. So it's quite fraught, this idea of having to disclose, but then, having to protect your IP as well. So how much disclosure is too much disclosure? And I think I've half given away the answer to this problem, in that maybe some is enough, but too much is too much. So if we think back about, there is a reason that I've gone on to explain what each IP right is about. This inherent idea of novelty and inventiveness being tested against claims means that maybe we we have a little bit of wiggle room to talk about things, to talk about features that are commonplace and not central to the crux of what makes our thing special. So if we can sort of think of what we're doing in a patent claim, what is it generically, and are those generic things pretty commonplace? Well, maybe we're happy about talking about those. But when it comes together to form, to give a different result, and that's what we would look to protect in a patent claim, that's the thing perhaps you don't want to disclose to anyone until you have a patent in place. Designs are very difficult to, I suppose, protect from disclosure if you have to disclose what the product is, because inherently design protection is about the appearance of a product. Now, the nice thing about designs in Australia is we have a system in Australia. Europe have the same. The US unfortunately don't. But we have a process whereby you can obtain design registration without having to have the design examined. So you can secure your filing date, you can protect the design, and you only ever need to spend the money to have it examined if you need to litigate. So it can just sit there. It sits there on the record until it needs to be enforced. And only at the time that you ever need to enforce it do you need to pay the fees to have it examined and go through that process of being tested against the substantive requirements of novelty or newness and distinctiveness. Unfortunately, the US, having a different system with their design patent system, don't have this process in place. So it's still quite an expensive and sometimes difficult process in the US. So the question is, what do you do? What do you do when you're asked for disclosure? Where do you sit? What's the answer to this problem of being sought disclosure, having to make disclosure to advance the commercialisation of your product? So I've only ever been able to find two answers to this question. The first one sort of centres around understanding what your audience really wants to know. And the second revolves around your IP strategy, which is, I think it's actually more meaningful than what it is that you're doing. So if we think about the audience, think about why you're pitching, who you're pitching to, and I don't mean pitching formally, but even if you're putting together an application for grant funding, it's essentially a pitch. So who is the audience? Do they really want to know about how you make the magic happen? If you're pitching in a public forum, you can usually speak about the market or the technical problem that you resolve without actually giving away the secret sauce, the essence of what you've done to address that problem. And you can talk about benefits that other people have experienced. So if you've run focus groups or even other people who have used it, what benefits have they had? So just avoid disclosing how you make or deploy the solution to the problem or how the business model works if a central part of your innovation in your business strategy is around a business model. So in private pitch sessions, you might actually be asked, look, go ahead.
Are you also including in this pitch about the this answer to this question about the audience, why they really want to know your pitch and what are they going to do with that information?
Potentially, yeah. So why do they want to know? Absolutely. You have to presume that they're going to do something with that information afterwards. So yeah.
Yeah. So what you just said there about being careful not to disclose too much, that's sort of to do with they might just take the information you've given them and run with it.
Exactly. So if someone's asking, if there's no end game, if someone's asking just out of interest, then obviously I would be most tight-lipped in that sort of scenario. If someone's asking for some legitimate reason, how much can you give? It's a difficult balancing act. But certainly if someone has no reason to want to know, then you do have to ask to yourself, why would they want to know? Is it really safe to be disclosing anything? So often in public pitch sessions, people will generally disclose fairly little, but a genuine investor may look to speak with you separately in private and ask more specific questions. But again, just be wary that it's only necessary to the extent that it's necessary for them to do. Again, your point, what do they want to do? Is it a legitimate activity? And if disclosure needs to happen, can you put a non-disclosure agreement in place? Can you put a patent in place first? So that's essentially, I've just addressed that. Non-disclosure agreements and confidentiality agreements. The one thing that they do that is useful is they do cement the date at which the discussion occurred. And I often have people say to me, well, non-disclosure agreements are not worth the paper they're printed on. And this is true. It's very difficult to take a non-disclosure agreement and take it to court and sue someone over it. One thing that is handy though is if someone has breached a non-disclosure agreement and you apply for a patent and that disclosure is discovered, there are ways that even private disclosures can be brought to light by third parties before the Patent Office. If that disclosure was not authorised, it can be waived from this requirement of novelty. So if it's a breach, if it was unlawful for that disclosure to take place, there are steps that we can take to produce evidence that it was derived unlawfully so that you can at least continue to get your patent granted. So from our perspective, it can be useful to have a non-disclosure agreement in place. For litigators, they'd say don't bother. So as a general rule of thumb, avoid specifics, avoid disclosing specifics. And this, knowing what it is, knowing what would need to be protected, what you ought to withhold from disclosure, it gels together with your IP strategy. And another approach around how to manage the need for a disclosure is maybe centre your discussion when you're pitching with investors or other individuals, centre it around IP strategy rather than the product. So this begs the question of what an IP strategy is. Now, nearly all businesses create IP, so all businesses should know whether they need to protect it. Not everything should be protected. Often it doesn't make much business sense or much commercial sense to protect a lot of things that that are created. Some business models are based on sharing IP, and it's almost a bit of a misconception that if we're in a sharing industry, we don't need to protect our IP, when quite the opposite can be true. If we want to control who is allowed to share and who isn't, and what they share for, what they then go on and do with it, we need IP rights in order to be able to tangibilise what it is that we've created and what we wish to share. Businesses are at great risk of wasting time and resources if they don't protect them. There are plenty of businesses that do things that would be copied if it weren't for IP rights. So that's sort of the most obvious reason for protecting IP and having an IP strategy in place. Essentially what we're talking about with an IP strategy is how the mechanism whereby a business combines their IP rights and non-rights to maximise the benefit afforded to them by their IP. So it's with everything available to us, what do we do to get the greatest commercial return? It's as simple as that. Most IP strategies are rooted in logic, not so much in we have a head count of 1 patent, 2 of these and 3 of those, and it doesn't really, if it doesn't hang well and it doesn't make sense, then it isn't a great strategy. So when we think about why we protect our IP, so we sort of go back, take a few steps back and go, is this worth doing? So why are we doing it? Why would we protect it? So if you wanted to de-risk your venture, these are the reasons that often people come to me and say, look, we need to protect our IP. They'll come to me telling me that we need to de-risk our venture because we want third-party investors to come in and they need to feel that their money is safeguarded. People come to me and say, this is a highly competitive industry we're working in, we need a barrier to the competitiveness of it, help protect us. People might come and say, look, the pace of industry is very, very rapid in our particular industry. We need something cost effective, but we need to do just enough to get us to the next iteration of this particular product. So in the pharmaceutical and medical device space, you've got these enormous lead times before a product can come to market and a whole lot of investment that has to go to get new medicines into the marketplace. So how do companies safeguard their position in the marketplace when that's going on? And patents are used for that very purpose. The sharing economy is often a scenario where we need to protect our IP because we need to control who's allowed to share, who's allowed to use this and who's not. I mean, how many of us have clicked through licenses, clicked through end user license agreements? That's all a form of IP protection.
They've changed a lot over the years. I actually read those things just for fun.
Do you not sleep well at night?
I don't read all of them. I have read some, I should have said it for fun. But even the terms and conditions of all those, from when they were started years ago, they've just gotten so much longer.
I like the European ones especially. Their language in contracts is it's flowery, it's fun. And actually privacy laws with click-through licenses, it's a huge onus in places like Europe that do have to protect users' privacy and can't disclose data and things like that. So let's just keep on going backwards, just keep on going back to the root of why we're doing this. So if we go back to the fundamentals of business basics, IP that's worth having is always customer-centric. Patents should protect a unique functionality that's meaningful to a customer. Otherwise, there is no point in spending the money to protect it. Designs should protect a unique aesthetic, something that's appealing to customers, or even if not aesthetically appealing, not directly appealing to the eye, appealing in form. Is it ergonomic? Does it have some other aesthetic to it that's appealing to customers? Trademarks should act as a badge of origin. In the marketplace, they have significant value when they can be identified and someone knows exactly who it is, whose trademark that is, whose brand that is, whose logo that is. And that's why we need, as a commercial entity, we would want to protect a trademark. So often we come across as practitioners, people who are kind of not sure whether they're looking at things from the perspective of IP push or IP pull. Are we pushing IP onto the marketplace? Are we pushing our ideas and what we think is valuable onto customers? Or are we getting that feedback and pulling it in? Because if we're pulling the IP needs from the marketplace, that's far more likely to get traction when it's embodied in a product than something that's come from our own understanding or our own ideas. We've got a sample size of 1. If we think something's a good idea, if customers at large think something's a good idea, it's got a much larger sample size and a much larger success rate. So most business strategies, when we're talking about tech-related businesses or new product-related businesses, revolve around a point of differentiation. What makes your product unique from all others out there? And what's your value proposition to the customer? You may have something incredibly unique, but there's no one or very few people who derive any benefit from that uniqueness. So think about it. A lot of people, I've seen a lot of people do user testing with samples of people who don't necessarily reflect real customers. The easiest way to get the most valid market feedback on a product is to actually sell it. Who will actually part with their money to buy it? And that there can be no better testing than actually making a sale. So then the question does come about, well, what is the competitive advantage in the marketplace? How do you combine these to provide an offering that's unmatched by everyone else? How do you combine all of these IP rights, well, all of the value that you impart to the marketplace, and then wrap it up in IP rights to protect it? So good IP protection should keep competitors as far away as possible from meeting that entire value proposition around brand, differentiators, market need. So intellectual property rights essentially act like an onion. At the core of the onion is your new product, your idea, your invention. And each intellectual property right adds another layer to the outside, making it more and more difficult for competitors to come in and gobble it up. At the very centre of the core has to be the business's competitive advantage. Anything that sets it apart, everything that sets it apart from what others are doing in the marketplace sits at the core of what all of these intellectual property rights are. So fundamentally, if an IP right is not contributing to wrapping the competitive advantage of the business up and keeping competitors away, it's not adding value, it's a waste of money. Often, I've seen a lot of applicants, patent applicants especially, who have, the patent process has been going on for years, and they find slowly over time the product sort of shifts. It shifts in response to what customers want, change in industry, and I think we're going to see a lot of this with AI, a lot of, when you have these innovations or advancements that change the way everything works. Products incrementally grow, they move towards iterations that meet customers' needs better. Patent attorneys will be chasing the broader scope of rights that can be granted, but from time to time you see these two things diverge. So you can, if you're not wary of what your IP strategy is, find yourself in a situation where you've finally got some patents granted, but they in no way reflect the product that you actually have in the marketplace. So that's a good way to remain clear on what you've actually got protected, is to maintain diligence around the strategy. It's also a very good cost efficiency measure to put in place, because anything that doesn't add value, you lapse it, you let it fall off. Okay, any questions? Is there any disclosure issues that anyone's come about that? I'll just touch on a few questions that people get asked, that I hear that people get asked reasonably often. So, do you have an IP strategy is one that people get asked quite a lot. So the preferred response is, of course, always yes. But it's not wrong to answer no. If your venture is still at the very early stages, if you are still very much in the sort of blue sky of the very early invention mode, it would be entirely justifiable to say, well, actually, it's too early now. We don't have all the information available to formulate an IP strategy. So no, we don't have one in place. We're still testing our value proposition. We're still building a strategic team, and we want that team involved in developing our IP strategy. We're not. So if all of the business building parts are still going on, it's also a valid reason for not having an IP strategy in place at any point in time. And that's actually often a question that has to go unanswered to government when I've had clients seeking grants, and they've actually, I think another one is a later one that I think I'm going to pick up on, Have you done any freedom to operate searching, and do you have an IP strategy in place? Well, neither of those questions are relevant to where this grant actually sits in terms of the time frame of the gap it's trying to meet. So it's sort of the question can't really be answered. The question is sometimes not appropriate for the timing of the business. So the second one, obviously, that gets asked quite a lot is your IP protected? And usually this comes about because someone's sort of thinking, well, there's a lot of funding that has to go into this business. How are we going to safeguard our investment? So, again, the answer may be yes. And it's often worth reflecting on things like whether non-disclosure agreements have been put in place, because it might be entirely appropriate for the timing of where the business is at to do nothing more than that. If you can keep a trade secret for a certain period of time before the business is closer to product launch, well, it would make sense to do that if there's very, very little risk that there's going to be a public disclosure of your invention. Is your IP protected? Well, the answer might be no, just because it's just too early. And that's fine, there's nothing wrong with that. This is one that gets asked quite a lot. Have you conducted any searching? So patent offices will do a lot of searching and patent attorneys will do a lot of searching, and essentially this is a process whereby we try to uncover as many disclosures as possible to those patent claims to see whether those claims are novel or not. So we kind of go out and seek out anything that could destroy the novelty of a patent to understand whether it's valid or not. So it is possible to do some level of novelty searching without a patent being in place, but you've always got this situation of, well, if we don't know what our claims would look like, we don't know specifically what we would want to protect, what level of benefit does searching provide? We do literature searches to understand the broader, area, the field of research or the field of endeavour. We might do some market research. Is there any point in doing patent research? It may be appropriate, it may not. The other question is, where does this searching, what perspective does it come from? You can search for the purposes of determining novelty of a claim, of patent claims, or you can ask the question from the perspective of validity. Is someone looking to how subject to an invalidation might your patent be if you were to seek one? Are there sort of people who have been contracted to do work who could later pop up out of the woodwork and say, oh, we first invented this, they're not entitled to it. So there are all of these ancillary sort of I don't mean to point any fingers, but the university sector, this tends to happen a lot. Who actually owns this? We don't really know. Should we progress with it? Because we don't know if we own it or someone else owns it, or the industry partner owns it. Which bit, how do we split hairs? And you come together, waste some years, and then one of the partners decides they don't want to be part of it, they won't sign any documents, and then it all just goes pear-shaped. So, yeah.
My question is, the first line up there,
yep.
We're not examined and therefore not assessed for some years. I'm not understanding the context of the question. Is you saying that's what generally happens, or it happens sometimes? So could you just clarify?
So a search, someone might ask for your patent to be searched because it's only a provision, it hasn't been searched yet. It's just not that stage in the queue. It's either a provisional patent, and so another year is going to pass before it's, at least, before it's examined, or it might be several, actually if it's still in provisional stage, it's more like at least 18 months. If you're going to go for an international patent, maybe a couple of years before it gets examined. So someone might say, well, it's all good and well that you've got a patent filed, but is it, what certainty, do you have any certainty that it's going to be able to be granted on those substantive grounds? So the novelty and inventiveness grounds, which is different to this idea of validity, which can mean an attack from any direction, even if it's someone who claims to be an owner, an entitled owner. This is one that gets asked an awful lot. and it's a very unusual question to be asking an early stage company. Do you have freedom to operate? So searches can be conducted of claims of all other patents that are out there in existence to determine whether what you're doing, what you're taking out to market, infringes someone else's patent. Often, this is asked, again, I've had federal government funding bodies ask this question of an early stage startup that's still some years away in product development, at least 5 years to the launch of a product into the marketplace, asking this question of whether they have freedom to operate. If they're seeking funding to go through further development and a substantial amount of development, they're not really going to be able to know with much certainty, because it's only that till a product is sort of pre-launched that you can say, okay, well, we know what it is well enough to know whether it's going to infringe another patent. It's difficult, it's unfortunate, but that's kind of the space we work in. More often than not, people who are experts in their field usually have a good gut instinct of freedom to operate and also novelty. And often people who have a depth of knowledge in a particular field will feel that there's a lot of opportunity to meet that novelty and inventiveness hurdle, and that's kind of probably more comfort than any level of searching can provide. So that's it. I hope that's helped answer a few questions.